In 2006, when she was dean of Harvard Law School, Ms. Kagan praised as her judicial hero Aaron Barak, who served on the Supreme Court of Israel for nearly 30 years. She called him, quote, "the judge or justice in my lifetime whom I think best represents and has best advanced the values of democracy and human rights, of the rule of law and of justice," unquote. Now that is not simply high praise, but the highest praise possible, for she said that Justice Barak was literally the very best judge anywhere during her entire lifetime in representing and advancing the rule of law. Who is this judge who, for Ms. Kagan, at least is literally the best representation of the rule of law? Judge Richard Posner, one of the great intellects in the law, has described Justice Barak as, quote, "one of the most prominent of the aggressively interventionist foreign judges," unquote, who, quote, "without a secure constitutional basis, created a degree of judicial power undreamt of by our most aggressive Supreme Court justices," unquote. Judge Posner concluded that to Justice Barak, quote, "the judiciary is a law unto itself," unquote. Now these and other examples over a period of more than 2 decades fit consistently together. They indicate that for most of her career, Ms. Kagan has endorsed and has praised others who endorse an activist judicial philosophy. She appears to have accepted that judges may base their decisions on their own sense of fairness or justice, their own values of what is good and right, and their own vision of the way society ought to be. This is an activist philosophy. And this activist philosophy, as she has said, is a thing of glory and best represents the rule of law. Now that is what her record shows. We will have to see what next week's hearing uncovers on this very important subject. There are also some specific subjects or controversies that must be explored. These might have been less important if Ms. Kagan did not have the record I just described. If she had not endorsed and praised judges making decisions based on their personal values and objectives, then evidence of her own personal values or objectives would obviously be less relevant. But as Ms. Kagan said in a 2004 interview, since a judge's personal attitudes and views make a difference in how they reach their decisions, quote, "the Senate is right to take an interest in who these people are and what they believe," unquote. I want to note 2 of the areas in which it appears that Ms. Kagan's personal or political views have driven her legal views. The first is abortion. When she clerked for Justice Marshall, she recommended against the court reviewing the decision in a case titled Anzaro v. Monmouth County Correctional Institutional Inmates. The U.S. Court of Appeals for the Third Circuit held that prison inmates have a right to elective abortions and that by refusing to pay for them, the county violated the Constitution's 8th Amendment ban on cruel and unusual punishment. Now, Ms. Kagan properly rejected this bizarre holding, even calling parts of the analysis ludicrous. Yet she urged against the court reviewing this decision because, as she put it, quote, "this case is likely to become the vehicle that this court uses to create some very bad law on abortion and or prisoners' rights," unquote. Broader policy objectives seem more important than even reviewing a ludicrous constitutional decision. The record also shows that later Ms. Kagan was a key player behind the Clinton's administration's extreme abortion policy. In May 1997, after President Clinton had vetoed the Partial Birth Abortion Ban Act, Ms. Kagan wrote a memo recommending that he support the substitutes for the ban being offered by Senators Daschle and Feinstein. She recommended this solely for political reasons because it might attract some votes from senators who would otherwise vote to override his veto. Had that strategy worked, of course, the substitutes would not have passed and partial birth abortion would have remained legal. The barbaric practice of partial birth abortion would have remained legal. Significantly, however, Ms. Kagan noted that the Office of Legal Counsel had concluded that these substitute amendments were unconstitutional under the Supreme Court's Roe v. Wade decision. There is no indication that she disagreed with this conclusion. The point is that Ms. Kagan urged a purely political position on abortion that was at odds with what the Clinton administration then believed the Constitution required. Once again, it looks like politics trumped the law. Another controversy involved the military's ability to recruit at Harvard Law School during Ms. Kagan's tenure as a dean. Ms. Kagan made her personal views and values as plain as anyone could make them, saying repeatedly that she had abhorred the military's policy with regard to homosexuals and calling it a profound wrong and a, quote, moral injustice of the first order, unquote. Federal law, known as the Solomon Amendment, denies federal funds to schools with policies or practices that have the effect of preventing military recruiters the same access to campus or to students that other employers have. A group called the Forum for Academic and Institutional Rights, or FAIR, challenged the law in court. Ms. Kagan first joined a legal brief filed in support of FAIR's challenge with the U.S. Court of Appeals for the Third Circuit. Within 24 hours of the court enjoining enforcement of the Solomon Amendment, Ms. Kagan again banned military recruiters from access to Harvard's Office of Career Services. She was not required to do this because the Third Circuit does not include Massachusetts. She kept the ban in place even after the Third Circuit stayed its own injunction while it was being appealed to the Supreme Court. In other words, Ms. Kagan denied military recruiters access even though the law still required access. She could have opposed the military's policy in various ways, but chose to do so in a way that undermined military recruitment during wartime. And the recruitment ban was lifted only after the president of Harvard University stepped in and overrode Ms. Kagan's decision. Ms. Kagan then joined a group of law professors filing a brief with the Supreme Court. To its credit, FAIR actually agreed with the government about the proper reading of the Solomon Amendment. But Ms. Kagan and her fellow professors urged the court to read the statute in an artificial and unnatural way that actually contradicted both the plain terms of the statute and the position of the very party on whose behalf she had filed her brief. The statute required that the military be treated the same as employers who are granted access to campus. Ms. Kagan argued instead that the military be treated the same as employers who are denied access to campus. Not surprisingly, the Supreme Court unanimously rejected Ms. Kagan's position, saying that her group of law professors simply misinterpreted the statute in a way that would literally negate it and make it, quote, a largely meaningless exercise, unquote. She did everything she could, including defying federal law and making legal arguments that even Justice Stevens could not accept to pursue her political objective. In closing, I want to come to the floor today. I wanted to come here today to describe for my colleagues the approach I am taking to evaluate Ms. Kagan's nomination to the Supreme Court. The most important qualification for the position is her judicial philosophy, the kind of justice she will be. The evidence for her judicial philosophy comes primarily from her record, and I've touched on some areas of concern that must be examined more closely, and then only a few. This is a grave decision. It is about more than simply one person. The liberty we enjoy in America requires that the people govern themselves, and that, in turn, depends on the kind of justices who sit on the highest court in the land. George Washington said this in his farewell address, quote, "The basis of our political systems is the right of the people to make and alter their constitutions of government. But the Constitution which at any time exists, still changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. Judges who bend the Constitution to their own values and who use the Constitution to pursue their own vision for society take this right away from the people and undermine liberty itself." Madam President, I yield the floor.